Hi, this is Charlie Jimerson from the law firm of Jimerson Cobb. I'm going to speak to you today about construction contracts. Just by way of background, my firm is a Florida-based construction law firm. I'm a board-certified construction lawyer, as well as all my partners are board-certified construction lawyers. We represent pretty much clients in most any phase of construction from most any industry, whether it be large general contractors, design build contractors, tradesmen, subcontractors, materials suppliers, ranging from a very small residential renovation all the way to large multi-million-dollar commercial or even public projects. So our range experience is very vast and very diverse amongst our group, and we're excited to have the opportunity to speak about construction contracts, particularly considering in the past few years there hasn't been that much transactional work by way of contracting, and we've done a lot of litigating on the back end. I'm writing my first subcontracts, doing AIA revisions in years actually now, in a couple of years. So, well, actually I began a couple of years ago writing them, but in the 08 to 10 time frame, as anybody who works in construction knows, those opportunities just weren't there. Everybody was holding what they had instead of commencing new work, and I'm excited to have the opportunity to get into contract law again, because it's something that I think my firm does well. It's something that I think that is at the core of any construction practitioner, is understanding specific terms by which you're going to put in the party's deal, and ultimately you may have to unwind in the event that there's a dispute. So should you wish to learn a little bit more about our practice and my qualifications, feel free to visit jimersoncobb.com. My profile should be there, as well as all the profiles of the partners, as well as a profile of our construction law practice. So without further ado, we're going to move into construction contracts. And construction contracts can take many different forms, whether it be a written contract, whether it be a oral contract, whether it be quasi-contract, contracts applied in fact and law, many different varieties. Construction contracts are very different in a technical nature from regular contracts, but fundamentally a contract is a contract. So at its root, construction contracts are construed and interpreted in accordance with contract law, whatever the law may be for the governing jurisdiction. Most often seen contracts, and we'll go over the AIA documents, but there's general construction agreements, there's a subcontract, there's various types of materials are supplied on credit applications, typically on an open account basis. So something could be as complex as a large lump sum contract with a 201 with a 50-page 201 addendum, or it could be as simple as a material supplier supplying lumber or plants on a 2-page credit application. So what we'll focus on are more of the meaty construction contracts, the AIA form documents, and some regular clauses that go within those type of agreements. Hopefully I'll be able to mention some practice pointers and identify some potential pitfalls, such that when you're putting contracts together or you're litigating them, some things to look for in enforceability. Regards to the AIA forms, there's a few common forms that I think that most any construction practitioner needs to just know. The 101 is the most widely used with a short form 201 supplement. In this 101, it's a lump sum contract, so it's really, you need to have a clear definition of the scope of work in order to have a good flat fee arrangement. when you're putting together a 101 on a lump sum type contract, it's really key to define quantity, quality, and time. You need to know what contingencies are not included in the price, how to deal with, for instance, cost increases, concealed project conditions, etc. You need to know whether the contractor warrants the plans and the site conditions. There's a lot in the 101 that you can probably need to be aware of and need to know, and I would encourage you to review those standard form of agreements as your baseline from which you gain your construction contracting knowledge. The 102, on the other hand, takes a lot of the risk out of it. That's a cost plus, can be with a GMP, guaranteed maximum price. One of the keys to the 102 is to clearly define what compensable costs are and what the fee structure is. Compensable costs, if they're not clearly defined, as you can imagine, there's some wiggle room there as to how far the project could, what the contractor could spend money on the project. Of course, there's some incentive if there's compensation is based on a percentage above costs to drive up those costs. So it's important to clearly define what compensable costs are. And then conversely, what's the penalties for cost overruns? What does a contractor have to submit to the owner? Is there any independent intermediary which certifies those costs? What documentation is required to prove costs? What do you need to supplement by way of pay applications, invoicing, etc.? One of the issues that arises with cost plus contracts is sometimes that can be more, owners can be more inclined to interfere with a contract at that point because their cost basis has them wanting to procure cheaper subcontractors and substitute them for contractor procured subcontractors. So that's something that probably your AIA forms you need to utilize. You think about those issues as you're getting people into AIAs or into cost plus with GMP. With respect to A201s, that's your real meat and potatoes of the contract. That's your general conditions of the contract. It's the most used AIA document. And that's where you really import your project-specific type of clauses that are going to truly govern a lot of the day in, day out operations of the project. So before we got into some contract clauses, I thought it was important to at least touch on project delivery methods in a concept basis. And I've set forth some project delivery methods, and we're going to focus our discussion, at least initially, on the design bid build and the design build delivery method. But there are some other delivery methods of administrating a construction project that you'll probably need to be aware of if you're going to be involved in construction contracting. And I've listed those on the slide. And one of the ones that we're not necessarily going to focus on, but we'll just go down the list, is the CM, construction manager type of agreement, at risk or not with risk. There's multiple prime arrangements that can be contracted around, integrated project delivery methods, and a real vogue topic these days are public-private partnerships. Public-private partnerships are something that I don't know its particular history, but I know in the economic downturn recently it became very au courant in the sense that public funds were strapped and construction was hurting, and the government has wanted more skin in the game from the private practitioners. And there's various terms that, depending on the type of agreement, type of project, that a P3 actually, various shapes that it can take. but it is a way of delivering goods and services and materials in a way that buildings and sites are being developed these days. What it means is something that probably you'll need to know as a practitioner. We're going to focus on the design bid build method first because it's the classic most used project delivery method. There's three main sequences to the phases of design bid build delivery method. There's the design phase, there's the bidding or the tender phase, and then naturally there's the construction phase. And under the design bid build phase, the owner typically contracts directly with the architect. Under the design bid build model, the owner typically contracts directly with the architect to prepare the design first. The design documents are then provided to the contractors for bidding, and the owner contracts directly with the contractor then. Typically under this model it's for a fixed price, and there's a lot of contract administration details that need to be ironed out, which we'll kind of break down by phase. But it's what you think of when you think of a construction project. Design professional, someone makes the drawings, bids it out, gets the GC in place. GC puts the plan together, or puts the project together by virtue mostly of utilization of subcontractors, and the GC is the one who performs for the owners, incorporating the work of the subs. So breaking it down a little bit further on the design build model, the design phase, in that phase, the owner retains the architect or a consulting engineer for infrastructure works to design and produce the bid documents, including the construction drawings, the technical specs, on which the various contractors will in turn bid to construct the project. For building projects, architect will work with the owner to develop the needs, to develop the vision, develop a written program documenting those needs, and then produce the conceptual or schematic design. The early design at that point is then developed, and the architect will usually bring in other design professionals such as the mechanical, electrical, and plumbing engineers, a fire protection engineer, structural engineer, sometimes a civil engineer, and often the landscape architect to help complete the construction drawings and the technical specifications. The finished documents, the bid documents that is, after those design works are made, they're coordinated by the architect and the owner for issuance to the general contractors during the bidding phase. Design fees are typically between 5 to 10% of the total project cost, but that may vary. In the design bid build model, the bidding phase is then opened. It can open with any qualified bidder. Qualifications are set by the owner and the architect. Or it can be select, in which a number of pre-selected contractors are exclusively invited to participate in the bid. The various general contractors bidding on the project obtain copies of the bid or the tender documents and then put them out to multiple subs for bids on the subcomponents of the project. Subcomponents may include much of the consulting components that I've referenced, as well as beyond, things such as concrete work, structural steel frame, electrical, HVAC, plumbing, etc. Bids are then based on the quantities of materials in the completed construction, or the operations needed to build, or simply at a lump sum cost. However, the bids are elucidated certainly within the confines of the bid documents. In public works, obviously there's a lot of specificity that's required in the procurement context, and I think that's really the bidding process in the public works is beyond the scope of this presentation. But other than to know with your respective state statutes, know exactly what's involved in the government procurement and the levels of details and the timeliness in which you send the RFPs out, or which responses to the RFPs are to be made, and exactly how you become a qualified bidder. Once the bids are received, the architect typically reviews the bids, seeks any clarification that might be needed, investigates qualifications, and then ensures the documentation is in order, including a bonding if necessary, and advises the order as to the ranking of the bids. If the bids fall within an acceptable range to the owner and the architect then discuss the suitability of the various bidders and their proposals. The owner is not obligated to accept the lowest bid, and it's customary for other factors such as past performance, reputation in the industry, quality of other work, etc., are utilized in the selection process. However, projects typically awarded to the general contractor with the lowest bid that is a qualified bidder. In the event that the bids do not satisfy the needs of the owner, whether for financial reasons or otherwise, the owner may choose to reject all the bids, at which time certain options become available to the owner. The owner could then rebid it, put it out for rebid, and maybe on a future date when the owner's needs are met, such as where more monies become available or the project costs go down. As materials tend to fluctuate in the construction industry, as they materials costs tend to fluctuate, and that may at times, as well as labor forces in the construction world, and that may affect the ability to bid, or it may drive the cost down, as well as cash flow on owner's side, as credit terms fluctuate with lending capacities and restrictions. So do the abilities of the owners to run projects which they could finance. So again, if the bids aren't in conformity or rejected, the owner can rebid at a certain time, abandon the project altogether, or perhaps issue a work order to have the architect redesign or revise the design. Sometimes, if it's in the contract with the owner, that may be at no cost. If that's in the contract with the architect, if that's previously negotiated. But the idea would be revise the contract or revise the bid solicitations so as to make the project smaller and more efficient, reducing elements of the project to bring the cost down, and then reissue the bid tenders. Or there's an option where the owner may select a general contractor, such as the lowest bidder or an experienced cost estimator, to assist the architect in excuse me, in design changes aimed at cost reduction. This process is often referred to as value engineering. So the bids may be altered to value engineer and then reissued. Now, the construction phase of the design bid build process, once it's been awarded to the contractor, the bid documents, again, the approved drawings and technical specifications, they may not be altered. Should design changes be necessary, whether initiated by the contractor, owner, or discovered by the architect may issue sketches or written clarifications, but the contractor really has as-built building requirements. In most instances, nearly every component of a project is supplied and installed by subcontractors. The general contractor may provide work with its own forces, but it's common for a GC to limit its role to primarily managing the process and daily activity on a construction site. During the construction phase, the architect also acts as the owner's agent to review the progress of work as it relates to pay requests to from the contractor, to issue site instructions, change orders or field orders, or other documentation necessary to facilitate the construction process, and certify that the project is built to the approved construction drawings. Now, like any other project delivery method, there's pros and cons to this, and we'll talk briefly about the cons and then we'll go through the pros. So the cons and the design bid build project delivery method are that design flaws can really cause project delays if the construction documents need to be redone to reduce costs. Also, this method can develop a cheaper is better type of mentality amongst the general contractors bidding the project. So there's a tendency to solicit the lowest cost subcontractors in the given market. In strong markets, GCs will be able to be selective about which projects to bid, but in lean times, like the ones we just went through, the desire to work forces the low bidder in each trade to be selected. Usually this results in for increased risk in the general contractor, but certainly compromises the quality of the construction. As a general contractor, another con is that as the general contractor is brought in to the team post-design, there's really little opportunity for input on the effective alternatives being presented. The design phase is already completed. Now the contractor has to build to design. If there's inherent design flaws, this delivery method doesn't necessarily afford the contractor to have that hands-on technical expertise and input that may otherwise be afforded. Of course, there's the pros that we've talked about is that the design team is impartial and it looks out for the best interests for the owner. Remember, the architect acts as the agent of the owner, so the architect is able to be that intermediary between the contractor and be the guidepost to ensure that the project stays on task in accordance to design. When there's the design build process, whereas the contractor and the architect essentially are the same unit, that layer of separation doesn't exist, and sometimes there's little inherent conflicts of interest that arise and make it challenging for owner-contractor interactions. The design, the pros to the design bid build process are also that the design team prepares documents on which all general contractors prepare the bids. So with this in mind, the cheaper is better argument kind of is rendered invalid since the bids are all based on complete documents. Incomplete, incorrect, or missed items are usually discovered and addressed during the bid process in the form of addenda. So I don't think it necessarily always carte blanche provides that a low bidder, cheaper is better type of mentality. I think that this method also ensures fairness to the potential bidders. It improves the decision making by the owner by providing a range of potential options. It creates a competitive marketplace, which I think that everybody tends to benefit from. It assists the owner establishing reasonable prices and expectations for the project. It uses the competition component of the bid selection process for the architect and the contractor to improve the efficiency and quality for the owners. So that is having an understanding of the roles of each party in the construction process is why we're walking through these delivery methods, so that as we get into different terms of contracts, you'll be able to understand exactly how it's administered, who has what obligations, and what some additional considerations are. We'll touch on design build before we then go into key contract provisions. Now, design build is a project delivery method used in the construction industry, and it's a method to deliver a project which the design and construction services are contracted by a single entity, a design builder or design build contractor. In contrast to what we just walked through with design bid build, where there's an owner contractor, owner architect, and a contractor, design build relies on a single point of responsibility for the contract. And it's used to minimize risks for the project owner and reduce the delivery schedule by overlapping the design phase with the construction phase of a project. The design builder, with its single point of responsibility, carries the very clear contractual remedies and responsibilities for the clients or the owner, because the design builder contractor will be responsible for all the work on the project regardless of the nature of the fault. The design build procurement changes the traditional sequence of work. It answers the client's wishes typically for a single source of responsibility in an attempt to reduce overall risks and project costs. I sense that this is really becoming a preferred project delivery method for major projects. I would say now about 40, I read an article recently about 40% of non-residential construction projects are design build projects, which is about 10% increase from the previous decade. Whether it will continue to increase at that rate, I'm not sure, but I know that this in-house design build component, especially on large commercial projects, is really the way to go, because owners get the white glove service that they're used to, and everything's all controlled and buttoned up in one contract. With that said, there are cons in this. Certainly cons for contractors, it's more liability. Have to have a much more vast staff and more capabilities. It creates powerhouse firms and less of the tradesmen, so to speak, the smaller construction companies, smaller GC types in the construction world. And I don't know that that's always best for the competitive nature of the construction world. I also think that it creates some really interesting insurance and bonding predicaments in situations such that to be a design builder, you've really had to have pretty substantial financial capacity, and I do think that it's cost-efficient manner is a way of doing good business. Another con is it doesn't invoke the competitive bidding process, in which you have prospective bidders bid on the same design, so you're not getting that market efficiency. Sometimes for owners also, the criteria to select a contractor is very subjective. It's difficult to evaluate and justify later when you're dealing with a design bid situation. And for better or for worse, for true or not, the design and price situation really arouses public suspicion at times when design builders are on a public project. So moving through from those project delivery methods, we'll move into key contract provisions and discuss some things that you need to be aware of if you're putting agreements together or if you're issue spotting. We're going to talk about scope of work and its importance. We're going to talk about the interpretation of contract documents, specifically how they're interpreted, the order of precedence. We're going to talk about flow-down provisions, what obligations those create, both on the subs and the GCs. We're going to talk about payment, which is a huge issue. We're going to talk about change orders. We're going to talk about liquidated damages and then delay damages. We're going to talk about indemnification. We're going to talk about the implications of additionally named insureds. We're going to talk about noticing requirements. We're going to talk about dispute resolution and attorney's fees. So moving to our first point, which is scope of work. A general contractor, for example, on scope of work benefits from a vague scope of work provision in its subcontracts, but would want something very specific provisions in terms of its general contract. The subcontractor necessarily would want a very specific scope of work provision in its subcontracts. An owner would likely want terms of the general contract to be vague and as inclusive as possible. Why? Well, liability is the reason. The scope of work is the basis for the contract. As such, it establishes the rights of the parties with regards to what is expected and what's promised. It's the most basic and most important term, and really forms the basis for all parties' performance. It's critical to have what I say is a clearly defined scope of work. Of course, as I said, on certain circumstances, vagueness and wiggle room and scope can be advantageous, but I tend to err on the side of having a crisp scope of work. The specificity of the scope of work really directly correlates to the party's liability. General contractors should not want to sign a general contract with a broad, open-ended scope, because then the owner could read much further into the provision that was intended. Should a conflict arise, the GC wants those terms to be as narrow and as precise as possible, so that they're not on the hook for more than what was anticipated and what they what they bid out. Same concept would trickle down to the subcontractor. If there's ambiguities in the scope of work, the courts will look to the parties of intent. What was the spirit of the spirit and nature of the engagement? What did the design call for this scope of work? Was the bid commensurate with what this scope of work was to be performed? Scope of work is a very costly piece of litigation because it's very fact intensive, and with fact intensive clauses or disputes, you're dealing with a lot of discovery, a lot of document exchange, a lot of depositions, witness testimony, factual interpretation, expert witnesses, things like that. And I think that scope of work issues are often avoidable through good contract drafting. So good contract drafting and issue spotting with your contract raises the question of what should I be looking at with respect to scope of work. Well, I think that you've got to, fundamentally, you want to look at what am I being contracted to do, and from a trade or from a GC sub perspective, what's included in this scope of work, what's expressly excluded in the scope of work, defining that clearly, making sure that it's within your purview, making sure that you've priced it accordingly is critical. And those often require technical questions that me as a lawyer, I can't always answer those questions. Those are items when I'm putting a contract together, I need to be able to rely on my client's technical interpretations of scope before I can provide any type of counsel in that respect. Sometimes there are rules in a contract or clauses that pertain particularly to ambiguities. How are ambiguities interpreted? How are ambiguities handled with respect to scope? What's the process there? Who's it construed against? Is it construed always against the drafter of the contract? Is it construed in favor of an additive change order? What are the ambiguity terms on this contract? And are there any allowances for undetermined quantities or quality? Things are fluid on a construction project. Quantities and qualities can change. And what are the allowance deviations in scope? Does your contract provide for that? You might want to consider it. What happens if the scope changes or evolves? Again, construction projects are up, they're down, they're left, they're right. They never go according to plan. So sometimes scope evolves. Sometimes the owner changes their mind on something. Sometimes the building to plans becomes impractical. Sometimes it just can't be done. So what happens when that evolves, and what are the liabilities there? Next, we're going to move on to interpretation of contract documents in order of precedence. Many different documents often are incorporated into a contract. For example, any given construction contract might include the main agreement, the general conditions, the supplementary conditions, exhibits, modifications, specifications, and drawings. So as you can imagine, if an agreement incorporates all of these particular contract documents, you've got a lot of reading to do as a contracting party to make sure you can fulfill all those obligations in those incorporated documents. You've also got a lot of reading to do to make sure that you're continually compliant with them. As you can imagine, there's large potential for conflict in one of those in a very large construction contract that incorporates many different addenda and external agreements. So you want to make sure that, number one, you've laid your eyes on all of them, that you understand them, that you can abide by them, but you also want to understand exactly and insert a provision that addresses the conflict amongst documents. Lawyers and clients, we're all human, and we're flawed in the way that we might put together a contract such that maybe a term conflicts with an existing executed contract, or maybe an issue arises that was unforeseeable that created a contract conflict, in which case hopefully that the governing agreement contains an order of precedence in which the contracts will be interpreted. Main agreement, then general conditions, then supplementaries, then and so on. You just got to establish some type of order of precedence, and that's something you really want to look for in your construction contracts and build in. As a general matter of interpretation, courts will favor specific over general terms, and ambiguities are construed against the drafter. So you want to consider that as well as you're putting together agreements. Now, flow-down provisions. Every contract, every project, the subcontractor particularly must ask themselves, have I seen or obtained a full copy of all the obligations or contracts that I'm assuming by the flow-down provisions? Contrarily, are there flow-up provisions as to the duties of the other parties? For example, does the GC assume any risk and in your scope of work as a subcontractor that you don't fully assume or agree to indemnify? Just by nature, flow-down provisions generally incorporate the general contract terms into the subcontracts. So most general contracts of good contractors will make sure their subs are required to abide by the terms of the prime contract. Got to look at that if you're a sub, and you got to understand what those contracts mean. It's the contractor's way of shifting risk to make the subs assume the risk that they've accepted, that the general has accepted with the prime contract. There's a lot of potential for conflict in clauses at that point with those multiple contracts. Conflict in clauses create ambiguities. Ambiguities means we need other parties to interpret the contract. It gets expensive, and it's something that can probably be cleaned up on the front end. Payment. We will move on to payment, and payment is perhaps the second most important term after the scope of work. It's an essential term to any contract. If you don't have a price, you don't have a contract. It's really critical. And the basis of payment can vary in the way that payment's facilitated. It can be a schedule of values, which is on line items of work within the scope, as to a noted percentage of completion. It can be a cost plus, which is reimbursable cost, plus overhead, plus profit, not to exceed a GMP price. Contracts in that scenario will typically define what reimbursable costs are. Or perhaps it's a units price basis of payment, like requirements contracts. For example, paving of all roads in the county for a year. Payment is going to be, just generally, it's going to be a process where the lender is going to, well, the lender is going to issue the payment. It's going to be trickle down to the owner, or an architect, who then pays the GC, who then pays the subs. But the payment application process is one in which is completely inverse. work performed by the subs, work performed is then submitted to the GC. GC then certifies it, who submits it to the architect. GC submits it by virtue of a payment application. Architect then certifies the work. Typically, it will then go straight to the lender. Lender then undertakes their own analysis as a construction lender to ensure that project documentation has been met, that there's lender risk has been mitigated, and then payment is issued. A lot of that, there's a lot that goes involved into that, but just to give you an idea of the timing of what occurs on that type of on a construction project as to payment, let's just say that a subcontractor performs work on January 1st. Well, the subcontractor is going to work, mobilize their workforce. They're going to purchase materials on their trade credit, and they're going to have to expend all of the money to get what they need to do to mobilize up front, and they won't submit their pay app until January 20th under our hypothetical. January 20th. So hopefully they've under that scenario they've fronted 3 weeks, sometimes 4 weeks of work, depending on the terms of the contract and how the pay app's coordinated. Contractor has 5 days, typically January 25th, they'll submit a pay application to the architect. If it's AIA, they're using AIA documents, it's a 702. The architect will then certify the draw request or the pay application, and then we'll submit it to the lender, at which times it's facilitated, and the owner probably doesn't pay the GC until about February 10th under our hypothetical. So at this time, and then the GC in turn doesn't pay the subs until about February 25th. So under this ideal situation, you're looking at 50 plus days, 55 days until the GC pays the sub. As you can imagine, that's quite crippling for the cash flow of a subcontractor. When you add retainage into that, it doesn't leave much room for subcontractors to have they better do good work, because if there's any offsets, it really would cripple cash flow, and cash flow is already crippled, but it could cripple financially a subcontractor who's out a lot of money for essentially 2 months of labor, having not been paid one single dollar on the project yet. With payment, you're going to need to, again, you're just issue spotting when you're seeing these contracts or when you're putting these contracts together. But fundamentally, you're going to want to ask, going to want to know what must be done and what must be furnished before payment is due. Are there contingencies or risks assumed before the right to payment matures? For example, a pay when paid clause, which we'll go into. When is payment due? Are there progress payments? If so, what prompts them? Are there dates? Are there milestone progress? Is it a payment at the end scenario? Your contract is going to affirm all of these positions and these provisions. Is there retainage? If so, how much? What are the conditions to payment of the retainage? Are there releases or payment affidavits that to be furnished before or after payment? How will that exchange work? What are the protocols and the procedures for ensuring that the releases and pay apps are submitted? Is the payment subject to approval by someone? I just went through the process where a typical large project where an architect's going to certify it off, but is there perhaps someone else that might be involved in that? If you're unpaid, how do you suspend or terminate work? What's that protocol? What's the noticing guidelines there? What can you suspend work for and not be in material breach? What obligations do you have if you are unpaid? Are there certain other things that you must do? What are the procedures? So payment's really critical. I touched on the 702, which is used in the pay applications. If you use consensus docs, a pay app on a GMP contract is consensus doc 291. 292 is for a lump sum project or a lump sum contract. and if you're using a schedule of values, the consensus docs will utilize 293. With the 702, on, let's just say you have a contract and there's a requirement for a pay application. The pay application is an AI document, 702, and it will generally, it's from the contractors to both, it's utilized by both the contractors in applying for payment and the architects for certifying the payment. So it includes specific information, including the total dollar amount of the work completed, the retainage, the total payments due to date, a summary of change orders, and the current specific payment that's requested. You can go to the AIA website and they'll have all of their forms that's available pertinent to this. But it's important to note that in the pay application, the contractor is certifying several things, such as the completion of the work and the financial accuracy of the application. And pay applications are tantamount to an affidavit. The Delta Fires sprinkler case, just for example in Florida, is one which stands for the proposition that pay applications can be used against the contractor as a certification of progress and payment due. Certainly used against them in a lien context as well, because both are formal certifications and sworn statements. Construction contracts, and moving along to in our payment section, they contain many risk-shifting provisions, and one such mechanism is a pay-when-paid provision that requires payment from one party before there is any requirement to pay the other party. Typically, this is a contract provision that's found in a contract between a general and a sub, and it shifts the responsibility, it shifts the risk of payment to the subcontractors, essentially saying, me, contractor, does not have to pay you, sub, until I'm paid from the owner. It shifts the risk of owner payment to the subs, and if you're a sub, you should think twice about signing these. Courts tend to disfavor them, but the clause itself must clearly shift the risk of payment from the contractor to the sub. You can't have any contractual ambiguities in this circumstance, and we'll go through a couple examples. As a starting point, the burden of drafting a clear and unambiguous pay-when-paid provision is on the general contractor. If it's the pay-when-paid provision is ambiguous, it will not have the desired effect, and it will result in the general contractor being required to pay the sub within a reasonable time. The next factor pertaining to enforceability on pay-when-paid provisions is whether the subcontract incorporates the term of the prime contract. That's not the next factor, but it's the next thing you want to look at, because it pertains to the next factor, which is ensuring that there's no contractual ambiguities and that the provision, the pay-when-paid provision, is clear and unambiguous on its face. So if the prime contract is incorporated into the subcontract, they require specifically that, let's just give you one specific example. Some prime contracts require that GCs provide an affidavit for payment certifying that it's paid all of its subs before the owner actually tenders payment on the project. If the prime contract is incorporated with the subcontract, as you can see, and the subcontract has a pay-when-paid provision, as you can imagine, that creates a contractual ambiguity which would perhaps most likely nullify the pay-when-paid provision. So if you're on the drafting side in favor of a GC, make sure that you've dealt with that issue in your contract. If you're a sub, just avoid signing any contracts with pay-when-pays if you can, if you have the business leverage to do so. The pay-when-paid provision has to be clear. Specifically, a clear expression that the payment from the owner to the general is an express condition precedent to the general's obligation to pay its sub. And of course, this would apply to both progress and final payments. They are enforceable in Florida. Courts are split on whether they're enforceable nationwide. I've got a list of states that have ruled that that pay when paid clauses are valid. That's Arizona, Colorado, Georgia, Florida, Illinois, Michigan, and Maryland. In contrast, California and New York have totally abolished the pay when paid clause. In other states, the enforceability of the provisions remain unclear, but the courts have tended to invalidate them. The following states tend to disfavor them on that issue: Alabama, Connecticut, Louisiana, Massachusetts, Missouri, Pennsylvania, Tennessee, and Washington, D.C. And the federal First and Fourth Circuits have also invalidated pay when paids for various type of reasons, most of them pertaining to public policy disfavoring anti-waiver provisions. The burden of clear expression is on the contractor, and I'll quote from you a specific citation from the case that I pulled, Everett Painting versus Padula and Wadsworth Construction, citing the Sneed Construction versus Langerman case. Quote, "The intent is in most subcontracts is that risk of non-payment does not fall with the subcontractor, and if parties do intend to shift the risk of non-payment to the subcontractor, the contract must unambiguously express that intention. Further, the burden of clear expression is on the general contractor." So that's to keep in mind as you're dealing with those type of provisions. Let me give you an example of a clause that was enforced as a contingent payment clause, and then I'll give you an example of a clause that was not enforced as a contingent payment clause. This is from the Dicer Plumbing Company versus Ross Plumbing and Heating case, Florida 2nd District case. Quote, "Final payment inclusive of retention shall be made within 30 days of completion of the construction project. Acceptance of the same by the owner, and as a condition precedent, receipt of final payment of subcontractor from the owner." So that's pretty clear and unambiguous as to where the risk shifting was going and who it was going to. Now here's an example of a clause that was not enforced as a contingent payment clause. Quote, "Under no circumstances shall the contractor be obligated to pay the subcontractor until funds have been advanced by the owner." And that's the Sharp versus Macri case, a Florida 2nd District case. If you want more examples of ambiguous and unambiguous clauses, see the Bentley Construction Development and Engineering Inc. case versus All Phase and Electric and Maintenance. That's a Florida 2nd District case as well. So I think that in reviewing those two clauses and comparing them to each other, there's clear specificity in the first one. As to the second one, not so clear. It just is a little bit more loose, and it doesn't shift the burden like pay when paids are required to. Now, there is an equitable defense to a pay when paid clause, and that's equitable defenses that a contractor must attempt to collect from the owner in good faith. So just because a pay when paid clause is in a contract, it doesn't necessarily invalidate the whole contract. It could be a litigated issue as to the efforts undertaken by the contractor, whether they were reasonable, whether they were in good faith, and it's something to consider. It's not a be-all, end-all. Another thing to consider is that just because a pay when paid provision exists, it doesn't necessarily vitiate your lien rights. You probably, and I know you do in Florida, but certainly in other jurisdictions, you may have a right to perfect and record and perfect a lien, and then pursue the security instrument from the owner if they have not paid. Now, there's another issue that pertains to payment, and that's typically it's a condition precedent, and that's a final payment affidavit. And we talked a little bit about that previously, about what it entails, but it's going to require a certification that the lieners have been paid in full, show the names of any lien or has not been paid in full. The owner may ask for this as part of the contract administration. So when you're putting contracts together, understanding what pay app you're using and what the requirements are is pretty important to administering payment. So let's talk about change orders and liquidated damages. Change orders are most contracts require written change orders. I think it's pretty important to require written change orders in a contract because you don't want loosey-goosey job site instructions governing your contract. You want to articulate in your contract who has the authority to sign the change orders, under what circumstances change orders will occur, and specifically address all of the issues pertinent there too. Think of change orders as mini contracts within a contract, because what it's doing is expanding the scope for a particular price. Oral change orders are enforceable, of course, if the contract provides it. And even if the contract doesn't provide it, if you can establish a course of dealing that says that the site project, the contractor accepted oral change orders 100 times, and for you to disavow the 101st is unreasonable based on the course of dealing between the parties, I think that you need to document it still internally and document it with some type of written record. I wouldn't risk it if I was overseeing a construction project, but there are circumstances where oral change orders will be enforceable. Public construction, they're hardly ever enforceable. I know they aren't in Florida. So with respect to change orders, you're really going to want to know, is the scope of work adequately defined to minimize disputes over what's going to be extra? Are there notice requirements for change orders for that extra work? Are there requirements for written authorization? What are those requirements? Who's the signatory? Who has to prepare the change orders? What's the form in which you have to prepare them? Must the owner be a signatory to the change order, or is the contractor itself granted discretion? What's the architect's role in that? Again, you want to make sure that if you can, contract out of a course of dealing, specifically say that there will be no course of dealing, and then if you're an owner, hold your contractors to it. You want to make sure that change order procedures and protocols are not ambiguous. When must it be signed, before or after the work? That's a pretty critical component. If it has to be signed before the work and it wasn't, it could affect the validity of the change order. As a sub and as a laborer and supplier, as a sub and a contractor, are you preserving your lien rights properly when you're administering your contract on a change order work? Are you not releasing them accidentally? And don't forget that change order, as a mini contract, you're now revisiting the initial contract analysis where you have to define your scope. You have to get your core terms in there for price, things like that. So what does the contract require in terms of that process? You may want to address that as well. Liquidated damages. Be careful here. You want to keep an eye on the timing within your contract and document delays with respect to liquidated damages. Communication is key. Liquidated damages can really add up in a contract, in a construction project, because inevitably they get delayed and off schedule. So what does the contract provide for liquidated damages? Are they something that are being implemented and utilized as a penalty? If so, they're not going to be enforceable. Was it pertinent to damages reasonably calculable at time of entering into the contract? If so, probably not going to be enforceable as well. So there's certain provisions that pertain to the enforcement of a liquidated damages clause. So you want to be prepared for addressing those in your upfront contracting, and when you're deconstructing the contract on the back end, make sure that you have a counter argument to that. They can't be unconscionable. You can't also, if you have LDs and you have actual damages, you can't get both. It's only one or the other. So what's it going to be? But just some things for you to think of when you're putting your contracts together as to LDs. What's the rate of liquidated damages, and how do they relate to anticipated actual damages? Is there a different liquidated damage rate for the delay in substantial completion versus final completion? What's the corresponding bonus for early completion? Are there liquidated damages available for delay? Those are in lieu of actual damages, right? You want to go through that process. I'm going to also touch on retainage, because that's something that's addressed kind of in the payment process as well. Retainage is the portion of the agreed upon contract price that is deliberately withheld from the work until the work is substantially complete, to ensure that the contractor or the sub actually complete the work and satisfy the obligations of the contract. It provides the incentive for the party to perform as they're required to. 10% is usually industry standard on retainage. Sometimes there's differing situations where if 50% completion of the project has been achieved, it might be 5% for the rest of the project. I know that there's some specific limitations on retainage on public works projects that you'll need to be aware of in your respective jurisdictions. Retainage, conceptually, it's well, historically, it's from 1940s English railway projects, wherein there was a flood in the market of all of these underqualified, undercapitalized contractors, and contractors began withholding 20% at the time, because that was their profit margin, on the notion that these subcontractors were having a hard time fulfilling contract requirements because they were undercapitalized or they were underperformers, etc. And it created that risk shifting from the contractor and the owner, and put a little bit on the subs. I think that it's something that's very much part of our construction culture here today, and again, it provides that incentive for the subcontractor to complete well. And it provides the security for the owner against liens, claims on the project, defaults under the contract as the project nears to completion. It's rife for abuse, as you can imagine. Contractors tend to withhold a lot more retainage from subs than they're actually being withheld from their owners. There's not a lot of leverage for subs in ensuring that abuse is not, there's no abuse on retainage. But retainage is going to be set forth in your contract, and if it's not set forth on your contract, it doesn't exist. It's certainly applicable to subcontracts as well as prime contracts. Again, amount and structure varies on a case-by-case basis, but substantial completion is typically going to be your triggering point for when retainage is due. Substantial completion is a common law defined term. That's usually when the owner can occupy the structure or is used for intended purpose, most of the time accompanied by when a CO has been actually issued. There are some alternatives to retainage, such as keeping items in trust, or actually giving the contractor ability to use retainage, such as having a trustee invest retainage while it's under management. We're going to move on to the timely performance and no damages for delay. No damages for delay cause. Timely performance is something you want to set forth in your agreement, and then you want to understand the effect of no damages for delay clauses so that you're able to write them in, depending on which side that you're on. Time is of the essence when it makes its way into a contract. Means that if time metrics are failed to be complied with, it constitutes a material breach of the contract. You want to, with respect to timeliness, it's always important to understand what are the notice requirements for time extensions. Are there any requirements? What is compensable delay? That's where those liquidated damages might come into play, and you want to make sure that the delay component is tied into something that's reasonable under the circumstances. But at a minimum, you need to understand what the timing of everything is. When's your delivery date? What's compensable? What if you're delayed and you can't move on as a sub or contractor, and you can't move on to the next project? What's the owner's delay? Let's say I'm building a hotel. The owner can't put occupants into the hotel. So there can be double sides on delay clauses, and understanding how this work is important for any practitioner. There can be no damages for delay clauses, and that means that if it goes over project, then you're just analyzing the material breach nature, and you perhaps even might be mitigated by a waiver of consequential damages provision in your clause. But I would tell you that there are exceptions to enforceability of even a no damages for delay clause, specifically if there's fraud, if there's willful concealment, or there's active interference. And willful concealment maybe of site conditions or certain issues that might be a hindrance into the progression of the project. Active interference is a big one, and that's often litigated in construction contracts, where you've got an overzealous owner who simply wants to micromanage the project. Sometimes that micromanagement transcends into is tantamount to owner interference, which then has all sorts of negative effects under the interpretation of the contract. Delay issues can be very complicated and expensive to litigate. If your contract has delay provisions, you need to get a construction lawyer, because it could get very costly very quick. I could give you an entire lecture on delay damages, but we'll move on for purposes of preserving our time. Moving on to indemnification. Indemnification is a risk-shifting provision. The concept is to hold someone else harmless. States differ in limits of these provisions. Florida limits indemnification somewhat, and that's cited there in your materials. You want to ensure the indemnity. In writing indemnification provisions, you want to ensure that the indemnity and the duty to defend obligations are in separate clauses, just in case one is stricken down. But some things, indemnitors are responsible for the losses and the cost of defense suffered by indemnities. So you want to make sure that if you're a general and your subs are constructing their project negligently or defectively, that you've got an indemnity provision in there that sufficiently covers you from the liability of the subs caused by the subs. From anybody's standpoint, in analyzing the indemnity, you need to understand who will indemnify whom, under what circumstances, for what amounts, what's the limits on that, what triggers indemnity. Will you be obligated to indemnify the other party from their own negligence? You shouldn't, but you want to look at that. Is there a duty to defend if the other party is at fault? You want to confirm that the limits in your contracts pertaining to indemnity are statutorily and commercially reasonable. And you really want to understand the risks that are being indemnified. This is a very expensive mistake to make by having a broad indemnity clause. You want to know what property damage to the owner or others from your work, bodily injury caused to others from your work, cost of defense, economic defense, or economic loss, owner delays, etc. How broad is that scope? So understanding that within your indemnity provision is key. And then, like anything else, what's the notice protocols on indemnity? If you don't follow them, is it going to be strictly construed against you? Can you dispute indemnity? Can you dispute the notice protocols? And one that I've seen that comes up a lot in my practice is who has the right to choose counsel for defense? A lot of times my client, I'll have a client on a defect case, and I've worked with them for years, and all of a sudden they're in a defect issue and they're being accused of some things they didn't do, and Now all of a sudden they have to work with a new lawyer because that's insurance counsel. So to what extent is that going to be covered? And that might be something that you have to iron out within your policy terms. So moving on to additionally named insured. This is a heavy litigated issue. If you are a sub, it didn't used to be, but it is now since the downturn. If you are a sub and you're required to name a contractor or owner as additionally insured, get with your attorney or your agent to make sure that the policy adjustment is made via an endorsement that actually alters the policy terms. Certificates of insurance won't cut it. Just by way of education, additionally named insurers typically are employed by the contractor to the downstream subs and so forth, and they're often a requirement of the prime contract, and they require that the liabilities caused by one person are going to be covered by virtue of having them an additionally named insured. Think of one point which I've seen a decent amount is that certificates of insurance will be rendered, but somehow along the way, no endorsement, no rider, no amendment was actually made to the insurance contract itself. And if that happens, then the coverage will not be triggered and the additional insured will not be covered as they intended to, which has a lot of implications from a liability standpoint, including, but not limited to breach of the contract. So notice. Let's move on to notice. Know your notice requirements and the dates and follow them. Your recovery will be delayed and potentially excused if you don't. Written notice is often required for various situations, including breach, unforeseen or differing site conditions, contract conflicts, or even initiating, and this is typical in AIA docs, initiating dispute resolution mechanisms. There are exceptions to written notice contracts, and those are typically in circumstances where the party against whom or is asserting a notice defense had actual or constructive notice of the issue, or there's been a waiver, often through course of dealing. If noticing has occurred, certain events triggering noticing has occurred multiple times and noticing wasn't required, yet performance was effectuated, notice might be waived through course of dealing. So termination. Let's move on to termination. This is a clause that you're going to, there's typically two types of termination provisions, termination for convenience, termination for cause. Convenience is typically exercised by the owner, and there needs to be some relief or it needs to be addressed in your contract. For cause, you need to have typical conditions which might merit owner cause, typical conditions which might merit contractor cause. Either way, make sure that as you're planning the marriage, you're planning the divorce. Termination is always included and addressed because that is important to know what the parties' rights are. You want to be asking yourself as you're drafting these documents, are there stated reasons that permit termination beyond material breach? What are the notice? Notice there's some common themes that I'm hitting on. What are the notice requirements? Do I need to send notice if I'm terminating? Do I need to send notice to the surety? Do I need to send notice to the lender? Are there any conditions precedent to termination? If I'm a sub, do I need to provide notice to the contractor? Do I need to provide notice to the architect? Do I need to give the independent decision maker an opportunity to come in and resolve the conflict? Is there a cure provision? You want to know if there's a cure. So you've noticed a default. Now what's the responsibilities and cure? And then once the contract's terminated, what are the stated rights and responsibilities? What do you have to do in winding down your contract? Do you have an obligation to mitigate? Certainly in common law you have an obligation to mitigate your damages, but you want to know in your contract, if it's terminated, what's your mitigation obligations? If you have termination for convenience provisions in your contract, is there a good faith requirement? What does that entail? How is that defined? Are there conditions precedent to avail the owner of this beneficial clause of termination for convenience? Do they have to do anything in order to get that? And what's compensable? If they, let's say it's terminated for convenience, well, what does that mean for the contractors? Obviously, they've bid out this project, and they have probably turned down other projects, so are there consequential damages that are available for contractors who have been terminated for convenience? And what are the duties? Think of the technical components too. What are the duties of transferring or releasing a permit if there's been a termination? What's your obligation in that respect? Moving in towards the end, we've only got a couple more items, but you want to understand what the dispute resolution mechanisms are in your contract. We've talked about the termination clauses, but let's say that there's a dispute, you terminate, and then there's a dispute. Does your contract have that IDM, the architect, the independent decision maker, who makes an interim decision on claims or disputes? If it's AIA, usually a pre-suit mediation is a condition precedent to moving forward to the dispute resolution mechanism. AIA contracts, the new forms are checked the box, so when you're executing the contract, you're either choosing whether it's arbitration or litigation. I'd much prefer being in litigation and could write a book on why, but I'm not going to bore you with that dissertation now. Attorney's fees. Plain and simple, attorney's fees are only given by statute or contract. Consider your facts when you're determining whether to include them. Are you in a position of power? Are you in a position where you could, if there's a dispute, you could bleed the other party through forcing them to pay an attorney without any chance of recovering their fees on that issue? You want to know if the other party's litigious. You want to know where their background is. If they're litigious, you might want to have a prevailing party attorney's fees in there. Or it could swing the other. Maybe you won't want to have one in there. Think about that. There's some issues to think about when you just before you blanketly put an attorney's fee provision into your contract. I'd say more often than not include one. That's my personal preference, but at any rate, it's always analyzed on a case-by-case basis. Does the attorney's fees always, when you are putting a provision in there, is it always going to be prevailing party? Do you want to put a provision in there that includes attorney's fees for indemnifying or defending an issue? And then do you want to put limitations on fees up to a certain amount, fees on appeal, fees, litigating fees? That's something that's come up. I've actually lost that motion before, moved for fees, and I asked for my fees, litigating whether I was entitled to fees, and they declined my fees on that. So now I write every contract that says, every contract I write says we're entitled to prevailing parties' fees, including fees for fees, fees incurred for trying to get fees. It's important to note a recent decision, and I think that this, of course, deviates by jurisdiction, but in Florida there's the Tritech versus Gale decision, which was on a construction dispute on a construction lien, where the court came down and said, yes, prevailing parties are entitled to attorney's fees under the statute, the lien statute, but based on whoever wins on the significant issues of the case, we don't have to determine who a prevailing party is on any given case. So instead of the net judgment rule, where if I win $1 and you win 0, I'm the prevailing party, or I win on 3 counts, you won on 2 counts, I'm the big winner because I won on the significant issues, the court can just say, well, you know what, there was no winner in the prevailing party on that, and they don't determine fees. For better or worse, that's what the law in Florida is. There may be similar law in your jurisdiction. That concludes my presentation today on construction contracts. I hope that you found value in going through some key provisions and understanding some key considerations. By no means was this an all-inclusive list, and I think that it'll just, if anything else, get you brainstorming and give you something to think about as you're putting pen to paper and documenting these construction contracts. Again, Charlie Jimerson, Jimerson Cobb. Feel free to contact me should you have any questions regarding the presentation. We are in Jacksonville, Florida. My number is 904-389-0050. Email address cjimerson@jimersoncobb.com. 1M in Jimerson, and you feel free to look us up on the web, jimersoncobb.com. Thank you for your attention today, and best of luck to you.